Tingles with flyby. Hello, how are you doing? Yeah, and how's your work going? That's good to hear. Well, very exciting day, signing the papers for your new property. Yeah, we just need to fill out the contract of sale. So I've got it here. I'll just be filling out all the details. So the address is at 27 Wistful Way So basically the parts of this page are just going through the basic details of the sale. So the particulars, special conditions, general conditions. So there is a cooling off period as well for all purchases within Tingledom. So you can end the contract within 3 clear business days. Obviously business days be going Monday to Friday, excluding any holidays. Unless there are any exceptions. So you do have to give written notice if you do want to end the contract earlier. You're entitled to a refund of all the money except for $100 or 0 to 2% of the purchase price if you end the contract. So these are the only situations where the cooling off period would not apply. You bought the property at or within 3 clear business days before or after a publicly advertised auction. Obviously that's not the case here. The property is used primarily for industrial or commercial purposes. It's not the case. Property is more than 20 hectares in size. Definitely not that big. You and the vendor have previously signed a contract for the sale of the land in substantially the same terms. So if it's for the house, but you kind of already own the land, which doesn't apply. And if you are an estate agent, then they kind of expect you to know what you're doing. But again, that's not you. So there is a big warning on this page, right here at the top, showing you, warning, this is a legally binding agreement in Tingledom and throughout the world, so make sure that you read all of it before signing. So you'll need to sign here and date here, and then print your name here. So the vendor what is the date to date? So the date of the sale will be this date, the date we've both signed this contract, just so you're aware of that. This is to purchase off the plan. So you may negotiate with the vendor about the amount of deposit monies payable under the contract of sale, up to 10% of the purchase price. A substantial period of time may elapse between the day on which you sign the contract of sale and the day on which you become the registered proprietor of the lot. The value of the lot may change between the day on which you sign the contract of sale of the lot and the day on which you become the registered proprietor. Yep, so our number here is plus 23 1895 8602. Don't use fax, and it is Tingledom Real Estate at tre.com.di, and the vendor is Tingledom Real Estate. So our legal practitioner is Jackie. Trying to think of the spelling on her name. Ranunculus. I think it's like that. She doesn't use that one, but she does have just a Jackie at tre.com.di. And purchaser, Gary Tingles. So do you have a legal practitioner or conveyancer? Oh, that was supposed to be a phone number. I do know our number. This is a +23 95 and then 8004. Okay, yep. So +23 1432 1689. Okay, great. Fax, email. Roger at dilegal.com.di. Okay. Volume 2, folio 36, being lot 18 on plan 3D. The land includes all improvements and fixtures. That was 27. Wistful. What was the Wistful Way? And Tingledom, of course. And the postcode for that one is 10042. Goods sold with the land. Because I think we have, there's a washer and dryer. There's also actually an old, still in good working condition, a, what's it called, lawnmower. And then there's a fridge, freezer, and stove. So the payment is just 1,000,000 tingle pieces, and the deposit is just 10,000. So that just payment is due for that on the 30th. But we've already received 5,000. So on the 30th, you just need to pay the remaining 5,000 tingle pieces. Okay. Price includes GST. Is this a sale of a foreign business? No. No margin scheme, and settlement is due on the 30th, 2018. No subject to lease. If this contract is intended to be a terms contract with the meaning of the sale, then add the word terms contract. Nope. Okay, so your loan. Who did you get your loan through? On the east or the west branch? Okay. Okay, Munter Mortgages. Well, yeah, they used to be the same company, but they've had a little bit of drama, but that's okay. So the loan amount is just the balance of tingle pieces, yeah? So 990,000. And are you already approved? Okay. You approved that a couple days ago. Okay. Not include special conditions. No special conditions. Okay. So that's all those details. I'll give that to you in a second just to sign. But we have these other parts of the contract. These are just your general conditions. Always just like to make sure that you're aware of all of those. So encumbrances. The purchaser buys the property subject to any encumbrances shown in the statement. There are no encumbrances. Sorry, just try and get that into your line of sight. Yeah, no, it's a little hard when we try and come out to the property and there's not much furniture. I always bring my trusty little desk along, but it can be a bit of a pain sometimes. So any reservations in the Crown and any lease referred to in the particulars, no leases. The purchaser indemnifies the vendor against all obligations under the lease that are performed by the landlord after settlement. So once settlement is done, anything to do with any leases is yours. In this general section 32 statement means a statement required to be given by a vendor under Section 32 of the Sale of Land Act, which would have been in there, but we have none of those. Vendor warranties. So these are the warranties for you. The vendor warrants that the general conditions 1 to 28 are identical to the conditions 1 to 28 in the standard form of contract of sale and real estate prescribed by the estate agent's contract regulations of 2008. The warranties and general conditions replicate the purchaser's right to make requisitions and inquiries. The vendor further warrants that the vendor has no knowledge of the following. Public rights of way over the land, so nope, should be nothing like that. Easement over the land, definitely nothing like that. Lease or other possessory agreement affecting the land. There was a lease, but that one was up in January, so no problems now. Yeah, no, they moved out. They actually were moving overseas. There's no notice or order affecting the land which will not be dealt with at settlement, other than the usual rates and notice of land taxes, and legal proceedings which would render the sale of the land void or voidable or capable of being set aside. No encumbrances as such. We also warrant that the warranties and general conditions are subject to any contract provisions in this contract and disclosures in the Section 32 statement that would be received under that statement. If Section 137B and 137C of the Building Act 1993 apply to this contract, the vendor warrants that all domestic building work carried out in relation to this construction or on behalf of the builder was done by a qualified worker, which is an existing property, so the vendor actually apply. All material used, again, this doesn't apply, and domestic building work was carried out in accordance to laws and legal requirements, which is correct just for any repairs that have been done. And then words and phrases used in general conditions which are defined have the same meaning in the others. So we've gone through that. Identity of the land. So this is just to kind of clear up if there are any issues within the contract itself. Any omission or mistake in the description of the property or any deficiencies in the area, description, or measurement of the land does not invalidate the sale. So that's very important. You have to be quite happy with the description and everything like that. Of course, it matches land records. We've gone through that previously, so I think you should be quite happy with that, but obviously that's your own thing to worry about. The purchaser may not make any objection or claim of compensation for any alleged misdescription of the property or any deficiency in its area measurements, or require the vendor to amend the title or pay any cost of amending the title. Okay? Service. The vendor does not represent that the services are adequate for the purchaser's proposed use of the property, and the vendor advises the purchaser to make appropriate inquiries. So while we have water, electricity, etc. on the property, internet connections, all that sort of thing, that's not guaranteed by the vendor. We can't guarantee that for sure, but that'll be suitable for your needs. It just comes basically as is. And the purchaser is responsible for the connection of services to the property after settlement and the payment of any associated costs. So while the services are there, obviously they have not been completed. Consent. The vendor must obtain any necessary consent or license required for the sale. The contract will be at an end and all money paid must be refunded if necessary consent or license is not obtained. That's fine. Transfer. The transfer of land document must be prepared by the purchaser and delivered to the vendor at least 10 days before settlement. So with the 10 days, I'll just write that out here on the side. That's going to be the 20th of the 3rd. And so you're just looking for the transfer of land document. So that's an important one. That one does need to be delivered, just so the sale can be completed. The delivery of the transfer of land document is not acceptance of the title. The vendor must prepare any document required for assessment of duty on this transaction relating to the matters, so any sort of taxes will be done by us. Or should within the knowledge of the vendor, if requested by the purchaser, must provide a copy of the document at least 3 days before settlement. So just let us know if you do want that. Release of security interest. So there's just a few points here. This general condition applies if any part of the property is subject to a security interest which the Personal Property Securities Act 2009 applies. For the purposes of enabling the purchaser to search the Personal Property Securities Register for any security interest affecting any personal property for which the purchaser may be entitled to a release, statement, approval, or correction, in accordance with the General Condition 7.4, the purchaser may request the vendor to provide the vendor's date of birth to the purchaser. The vendor must comply with the request made to the purchaser under this condition if the purchaser makes the request at least 21 days before settlement, but we will waive the 21 days if you do want to make a request on that, because we're more closer than that. 7.3. If the purchaser is given the details of the vendor's date of birth under condition 7.2, the purchaser must only use the vendor's date of birth for the purpose specified in this condition and keep the date of birth of the vendor secure and confidential. Super important. Please don't give out any of our information if you do seek that. 7.4. The vendor must ensure that at or before settlement, the purchaser receives a release from the secure party releasing the property from the security interest. And, that was just the first page of that. Put that here. He's got a few more pages to go. Oh, we don't have to go through everything. I gave you a little rundown. Yeah, just basically this is going through the paperwork about the personal securities. The vendor is not obliged to ensure that the purchaser receives a release, statement, approval, or correction in respect of his personal property if the purchaser intends to use predominantly for personal, domestic, or household use and has a market value of more than, that should say, yeah, the tingle coins. Okay. The vendor is obliged to ensure that the purchaser receives a release, statement, or approval of correction in respect to the personal property describing the general condition. If the personal property is of kind that must be described by serial number in the Personal Property Securities Register, and the purchaser has actual or constructive knowledge that the sale constitutes a breach of the security agreement. A release for the purposes of the general condition must be in writing, that's fine. Must be effective in releasing the goods from the security interest. We don't really need anything about, yeah, that shouldn't be relevant to us, so we'll just kind of cross those out. Here, the builder warranty insurance. The vendor warrants that the vendor will provide at settlement details of any current builder warranty insurance in the vendor's possession relating to the property if requested in writing. General law land. This general condition only applies if any part of the land is not under the operation of the Transfer of Land Act, which it's not. So that's fine. Okay, into the money section. At settlement, the purchaser must pay the balance, and the vendor, on our side, must do all things necessary to enable the purchaser to become the registered proprietor of the land, and give either vacant possession or receipt of rents and profits according with the particulars of the sale. The vendor's obligations under this general condition continue after settlement, and the settlement must be conducted between the hours of 10 a.m. and 4 p.m. unless the parties agree otherwise. For payment, the purchaser must pay the deposit to the vendor's licensed estate agent, so to us, And the rest of those don't apply because that's who we all pay to. If the land sold is a lot on an unregistered plan of a subdivision, then the deposit must not exceed. I don't need to worry about that. Okay. The purchaser must pay all money other than the deposit to the vendor or the vendor's legal practitioner or conveyancer in accordance with the written direction of the vendor or the vendor's practitioner. So we'll give the details of that. At settlement, payments must be made or tendered in cash. So these are the options. You have in cash, by check drawn on an authorized deposit-taking institution, or if the parties agree, by electronically transferring, this is our preferred method, the payment in the form of cleared funds. For the purpose of this general condition, authorized deposit taking institution means a body corporate in relation to which an authority under the section 9.3 of the Banking Act is in force. So basically a bank, credit union, that sort of thing. At settlement, the purchaser must pay the fees on up to 3 checks. We don't use checks, so you don't have to worry about that part. Stakeholding. The deposit must be released to the vendor if the vendor provides particulars to the satisfaction of the purchaser that either there are no debts secured against the property, or if there are any debts, the total amount of those debts does not exceed 80% of the sale price, and at least 20 days have elapsed since the particulars were given to the purchaser under paragraph A, and if all conditions of section 27 have been satisfied. The stakeholder must pay a deposit, any interest to the party where the deposit is released, the contract is settled, or the contract is ended. The stakeholder may pay the deposit and any interest into court if it is reasonable to do so. GST. The GST shall not apply. Does not have to apply any, but basically this is just saying you must pay if any action is taken by the purchaser after the sale. If there's a change of use, that would change it to farming or something like that. Or if the particulars of the sales applied made under this contract are on land which is a farming business. And if the particulars of sale are made of going concern. So just those other parts. That's just more about GST, but that won't apply, so if the particulars of sale, this is more GST. So GST should be not an issue at all. Loan. If the particulars of sale specify that this contract is subject to a loan being approved, because you're purchasing it with a loan, this contract is subject to the lending approval of the loan, which you already have, but as long as that's not withdrawn by your banking institution. By the date or date allowed by the vendor. The purchaser may end the contract if the loan is not approved by the approval date, but only if the purchaser immediately applied for the loan, did everything reasonable required to attain approval of the loan, and serves written notice ending the contract to the vendor within 2 clear business days after the approval date or any later date allowed by the vendor, and is not in default under any condition of the contract when the notice is given. All money must immediately be refunded if the contract is ended, so we would refund anything to you there. Adjustments, this is just periodic outgoings. These are payable by us. The periodic outgoings and rent and others must be apportioned on the following basis. So we are liable for everything up until the day of settlement. And the land is treated as the only land which the vendor is the owner. The vendor is taken to own the land as a resident of Tingledom. We do borrow these, but anyway. And any person's statutory benefit available to each party to disregard and circulating. Okay. Time. Time is of the essence in this contract. Time is extended until the next business day, if anything falls on a Saturday or a Sunday, or a holiday. Service: any document sent by post is taken to have been served on the next business day. Emails are taken to have been served within the time of receipt, according to the Electronic Transactions Act of 2000. Any demand, notice, or document required to be served or on any party may be served on the legal practitioner or conveyancer, as if that's the original party. This general condition applies only to the service of any demand, notice, or document. So the ones we were talking about earlier, like a request for any particular, date of birth or that sort of thing. Nominee: the purchaser may nominate a substitute or additional transferee, but the named purchaser remains personally liable for the due performance of the purchaser's obligations under this contract. So even if you have a nominee, it still makes you liable. Liability of signatory: any signatory for a proprietary limited company purchaser is personally liable for the due performance of the purchaser's obligations, as if the signatory were the purchaser in the case of a default by a proprietary limited company purchaser. Not really relevant to you because you're not, but you can have a nominee as well. Guarantee: the vendor may require one or more directors. We don't need that. Notices: the purchaser is responsible for any notice, order, demand, or levy imposing liability on the property that is issued or made on or after the day of sale. So basically, once we reach the date of sale, all of it basically passes into your hands. The purchaser may enter the property to comply with that responsibility where action is required before settlement. Inspection: the purchaser and or another person authorized by the purchaser may inspect the property at any reasonable time during the 7 days, that's just days, not business days, preceding and including the settlement day. And then the terms contract, 23(1). If this is a terms contract, which it's not, so I'm not worried about that part. And that's all terms contract. Loss or damage before settlement. So these are just some important things to know. The vendor carries the risk of loss or damage to the property until settlement. The vendor must deliver the property to the purchaser at settlement in the same condition as it was on the day of sale, except for fair wear and tear. The purchaser must not delay settlement because one or more of the goods is not in the condition required by the general condition, but may claim compensation from the vendor after settlement. The purchaser may nominate an amount exceeding $5,000 to be held by a stakeholder to be appointed by the parties if the property is not in the condition required by general condition above, and the nominated amount may be deducted from the amount due to the vendor at settlement and paid to the stakeholder, but only if the purchaser also pays an amount equal to the nominated amount to the stakeholder. The stakeholder must pay the amounts referred to in General Conditions 24.5 in accordance with the determination of the dispute, including any order for payment of the costs of the resolution of the dispute. Breach. A party who breaches this contract must pay to the other party on demand compensation for any reasonably foreseeable loss to the other party resulting from the breach and any interest due under this contract as a result of the breach. Default interest. Interest at a rate of 2% per annum plus the rate for the time being fixed by Section 2 of the penalty interest rates is payable on any money owing under the contract during the period of default without affecting any other rights of the offended party. A default notice. A party is not entitled to exercise any rights arising from other parties' default other than the right to receive interest and the right to sue from money owing until the other party is given and fails to comply with a written default notice. The default notice must include and specify the particulars of the default and state that it is the offended party's intention to exercise the right arising from the defaults unless the default is remedied and the reasonable costs incurred as a result of the default and any interest or payable are paid. And then if the default's not remedied, these are obviously just provisions in case there are any issues on either party. It's always better to just have this stuff laid out in black and white so that everybody knows if any problems arise. It doesn't mean that we think any problems are going to arise, of course. All unpaid money under the contract becomes immediately payable to the vendor if the default has been made by the purchaser and is not remedied and the cost and interest is not paid. The contract immediately ends if the default notice also states that unless the default is remedied and the reasonable costs and interest are paid, the contract will be ended in accordance with this general condition, and the default is not remedied and the reasonable costs and interest are not paid by the end of the period of the default notice. If the contract ends by a default notice given by the purchaser must be repaid any money paid under the contract and be paid any interest reasonable cost payable under the contract. Although same amounts are a charge on the land until payment, and the purchaser may also recover any other loss otherwise recoverable. We're almost there, just a couple more to go. If the contract ends by a default notice given by the vendor, the deposit up to 10% of the price is forfeited to the vendor as the vendor's absolute property whether the deposit has been paid or not. The vendor is entitled to possession of the property. In addition to any other remedy, the vendor may within 1 year of the contract ending either retain the property and sue for damages or breach of contract, or resell the property in any manner and recover any deficiency in the price of the resale, any resulting expenses by way of liquidated damages. And the vendor may retain any part of the price paid until the vendor's damages have been determined and may apply that money towards those damages. And any determination of the vendor's damages must take into account the amounts forfeited to the vendor. And the final part is the ending of the contract does not affect the rights of the offended party as a consequence of there you go. That's all the details of the contract. So that covers all the general conditions warranted by law. Just so that you're aware of those. I always like to go just in a bit of detail, particularly for people going through their first time. So all you need for you then is just on this page 2, these 3. So just give those over to you. If you sign that, then I'll go ahead and make a copy, and we'll both get a copy. Okay? Yeah, no, feel free to read in any detail that you need to. Yeah, for sure. Oh no, I'm not in any rush. Take all the time that you need. Thanks for watching this video. If you liked it, please be sure to give it a thumbs up. And remember that if you do comment down in the comments down below, that you do have a chance to be featured in my monthly viewers appreciation on the 25th of each month. And I do try to reply to all non-troll comments. So if you have a serious comment or anything, please let me know down in the comments. If you are new to my channel, please consider hitting the subscribe button so that you can see more videos like this one.